Now, let's talk about two other important matters. That is, one is called Section 48 bar, the other is Schedule 3 requirement. So Section 48 bar bars people from making a valid application. So according to Section 46, you have to satisfy Schedule 1 requirement if you want to lodge an application. But if you're impacted by Section 48, you won't be able to make a valid application. That particularly means that if you're in Australia, if your previous visa had been refused or cancelled after your last entry, and you're not holding a subtended visa, e.g. you don't have any visa or holding a bridging visa, you won't be able to make a valid application for a new visa onshore, except for a group of visas. That group of visas includes partner visa. So Section 48 bar does not bar partner visas. If you're lodging it the first time, if your partner visa hadn't been refused. If it hadn't been refused, sorry, it won't help you because that you won't be able to do it repeatedly. But if your previous visa, student visa got canceled or refused, or you're unlawful, if you can demonstrate you have 2 AAA forms, you will be able to make a valid application. That's Section 40 bar. It's about the validity of requirement. The second thing is Schedule 3. Schedule 3 requires that at a visa application, at the time of visa application, you must be a subtended visa holder. If you are not holding a subtended visa, e.g., you don't have any visa or holding a bridging visa, then you could be subject to Schedule 3. And Schedule 3 is basically about 28 days. You have to lodge your partner visa within 20 days of your previous visa, subtended visa expiry. Or if you didn't, you apply later, you must satisfy the minister there are compelling reasons for not applying those criteria. So a lot of people would be impacted by this. If you're on AET, for example, then you could be subject to Schedule 3 waiver, and you have to demonstrate compelling reasons. The compelling reasons is not a very low threshold. It is rather a high threshold. You have to tell them why on earth you cannot lodge your application offshore, why you have to stay here and lodge it. And if you didn't lodge it onshore, there could be devastating results to Australia or to Australian citizen or PR, or other, compelling reasons. There are not particular examples, but if you have a child, a young child, of course, that's a very good example of compelling reasons. If you are the sole bread maker, you're the person bringing all the money for the family. If you depart, your family will be in trouble because they don't have money to survive, pay rent, etc. Yeah, that's another good compelling reasons. But you can't just say, oh, I miss her, I miss him, I can't live one day without him, but purely based on that on a claim. That's not enough. And you won't be able to do that. And if you doubt that you would satisfy the Schedule 3 requirement and you're on a bridging visa, you're on a AAT, for example, but you're certain that your relationship is genuine, you just don't want this extra risk factor, what you can do is you can apply for bridging visa B, depart Australia, apply for 309, which is the offshore visa application. And that one, you're not impacted by the Schedule 3 or the Section 40 bar. The downside is that you won't be able to have a bridging visa after your AAT is decided. Of course, if you go for judicial review, you will be able to continue, all right? But you can come back and wait for your visa. But if you lodge 309, the 309 requires you to be offshore when the visa is granted. So you have to depart. But the department will tell you they're ready to grant, then you have to depart. Those are under normal circumstances. Under COVID, it just makes things a lot more complicated. But I don't see a straight solution at the moment. So yeah, that's the situation about Schedule 3 and Section 48. I just recently saw a decision made by a case officer from Cambodian post of the DFAT. The person mixed together of the Section 40 bar requirement and Schedule 3, which is interesting. So, but anyway, let me tell you that many of the offshore case officers are not well trained. They sometimes make very stupid claims, and decisions. I've seen a trend that Vietnamese nationals, their onshore visa application will be assigned to the Ho Chi Minh City Post, for example. And those decisions made by those DFAT officers are quite different from the Australian style. And it sometimes can be ridiculous. All right. Challenge it at AAT, at a tribunal, if you think that's really unfair. And sometimes the claims are not very logical. What's important is that at AAT, you have a new chance to present your case and make your arguments. So you can fix it. All right. And another thing I wanted to discuss regarding Schedule 3, compelling reasons. It used to be a time of visa application criteria. Actually, it used to be time of decision criteria. Then it changed to be time of visa application criteria, and then changed back to a decision criteria by a court case. What I'm saying is, in English, is that you can demonstrate your compelling reasons when they look at your case, either at the department level or the tribunal level. You can show them that this is your situation. For example, you apply for the partner visa without any special reason, but you are not a holder of substantive visa, and your visa got refused, and you apply for AAT, and so many years has passed, you already had a child, or situation significantly changed. So at the tribunal, you can present your case, you can present your current situation to satisfy compelling reasons. Just a reminder.